SCOTUS reshapes the Second Amendment battle. Every courtroom war reaches a point where the narrative appears finished, yet in truth, it's merely transforming. That's precisely what unfolded this week when the High Court delivered a subdued emergency directive that may ultimately redefine how states protect their firearm freedoms from Washington's encroachment. No grand pronouncement, no verbal arguments, no declaration from the dais, merely a notation on the docket's roster. And abruptly, Missouri's Second Amendment Preservation Act faces a dramatically altered trajectory than observers anticipated. For those not following closely, SAPA statutes don't establish fresh firearm entitlements. They center on rejecting implementation of federal weapons rules that jurisdictions consider infringe upon established liberties. It's a judicial approach grounded in identical constitutional principles that fueled sanctuary jurisdictions throughout the Trump era. Except now the subject isn't migration or narcotics, but firearms, and the national administration seeks to terminate that approach. Yet, the High Court didn't destroy SAPA. Rather, it rejected expedited consideration via an 8-against-1 ruling that sustains the litigation, transfers authority to inferior tribunals, and maintains the option for a comprehensive merits confrontation eventually. And that rejection carried a caveat, a pledge from the national government to constrict its own triumph. That nuance carries weight because in charter disputes, commitments to the bench represent bargaining power, and bargaining power transforms into coercion once proceedings descend. Part 1. The Directive. The High Court delivered an emergency directive regarding Missouri's Second Amendment Preservation Act, but the headline isn't the rejection per se. The headline is what that rejection now triggers. For months, Missouri has attempted to safeguard its SAPA statute from national meddling, contending that states may decline assistance in executing federal weapons regulations they consider unconstitutional. The tribunal declined the expedited petition, which superficially resembles defeat. But in Supreme Court terminology, rejections in urgent posture seldom conclude narratives. They frequently relocate combat to alternative arenas. For firearm proprietors, the rejection doesn't terminate SAPA. It merely propels the dispute back into inferior tribunals, where the national government previously pledged to constrict their triumph. That pledge carries greater significance presently than when initially uttered. Essential points. The High Court rejected expedited examination. The dispute returns to the trial tribunal. SAPA persists within litigation. The genuine narrative involves whether the national government will honor the constriction it pledged, because that alters the complete practical terrain. Part 2. SAPA's actual function. Missouri's SAPA statute, enacted in 2021, wasn't regarding invalidation, despite adversaries' characterizations. It didn't declare federal weapons statutes null. It didn't declare national agents cannot execute them. What it did declare is that Missouri's state personnel wouldn't participate in that execution if the statutes were considered to infringe the Second Amendment. And SAPA incorporated an additional element. It established a private right of action. If a Missouri functionary assisted in executing national weapons limitations that residents considered violated their entitlements, those residents could litigate. That architecture inverted the conventional authority dynamic. National agencies depend upon collaboration from state and municipal authorities. If states reject collaboration, execution becomes more emblematic than operational. Missouri also attached assistance and appropriations to the statute, complicating state assets from indirectly subsidizing national weapons regulation. In charter terminology, that falls beneath the anti-commandeering principle, the identical principle that permitted sanctuary states to refuse national cooperation regarding expulsions, cannabis policy, and alternative enforcement priorities. Essential points. SAPA constrains state collaboration, not national enforcement. Private right empowers residents, not administrators, constructed upon anti-commandeering precedents. This explains why SAPA statutes alarm Washington more than emblematic pro-firearm declarations. They alter enforcement capability, not merely rhetoric. Part 3. The inferior tribunals retaliate. When the Justice Department sued, the trial tribunal adopted the widest conceivable approach, striking SAPA completely and issuing a comprehensive prohibition. That determination argued SAPA extends excessively because because it impedes national law and encourages litigation against state functionaries. Upon appeal, the Eighth Circuit reinforced and concurred with the national government, not because the architecture was invalid, but due to the statute's objective and underlying Second Amendment rationale. Missouri argued the Eighth Circuit inadvertently revised the anti-commandeering principle. Beneath conventional anti-commandeering, declining assistance differs from interference. But the Eighth Circuit treated adherence to the state statute as essentially inaction, as though it constituted enforcement or obstruction. That reversal triggered concern because if adherence equals enforcement, then sanctuary policies of every variety become suddenly exposed. Essential points. Federal tribunal struck down completely. The Eighth Circuit treated non-collaboration as enforcement. Anti-commandeering principle could be constricted if that perspective stands, and that's where the High Court determination becomes tactically significant. Part 4. The 8-against-1 indication. Numerous analysts obsessed over the 8-against-1 tally, presuming it reflected unambiguous consensus against SAPA, but High Court emergency directives seldom address merits. They address scheduling, posture, and procedural readiness. Justice Thomas stood as the sole dissenter. Unsurprising, given his extensive record defending both the Second Amendment and structural federalism. The intriguing detail is that none of the conservative jurists joined him, neither Alito nor Gorsuch, who have been forceful regarding anti-commandeering in prior disputes. But urgent posture carries weight. SAPA hadn't reached final judgment, and the administration itself represented that it would constrict the prohibition if proceedings continue. That representation provided the tribunal an escape: decline the expedited petition, avoid signaling merits, and permit inferior tribunals to remedy the excessive breadth. Essential points. 8-against-1 rejection isn't a merits determination. Urgent posture provided the tribunal effortless departure. Thomas maintains his structural federalism trajectory. Occasionally, absence of determination prepares superior resolution subsequently. Part 5. The Pledge. The most neglected component of this dispute isn't at the High Court. It resides within Justice Department submissions. When the Trump administration assumed control, they informed the tribunal that while they consider substantial SAPA provisions invalid, the trial tribunal's prohibition extended excessively. They argued that obstructing pure non-collaboration violates the anti-commandeering principle, and they declared in writing that when proceedings returned to the trial tribunal, they would constrict the prohibition themselves. That pledge contributed to the High Court's decision to abstain from intervention. Rather than engaging directly, the tribunal effectively communicated, "You declared you'd constrict it. Proceed, constrict it." But months have elapsed, and the constriction hasn't materialized. That renders the subsequent procedural maneuver the most critical, whether the Justice Department honors its vow or whether Missouri must combat to compel the constriction through litigation. Pledges to the tribunal aren't casual. They generate expectations and coercion. Essential points. The Justice Department pledged to constrict its own triumph. The High Court relied upon that representation. Presently, observers monitor whether that pledge materializes. The fulfillment or violation of that pledge alters the political narrative and the constitutional narrative. Part 6. What's genuinely at risk? This confrontation has never concerned solely Missouri. SAPA statutes are proliferating. Nearly 12 states have contemplated versions, and multiple municipalities have adopted municipal anti-enforcement measures connected to firearms, expression, or property confiscation. If SAPA endures in even partial form, it establishes a functional template, and once a template exists, attorneys duplicate it. Conversely, if federal tribunals can eliminate SAPA entirely by redefining non-collaboration as obstruction, then the anti-commandeering principle contracts, and if it contracts within the firearms context, it contracts everywhere else. Sanctuary immigration, narcotics policy, expression enforcement, information privacy, pandemic mandates, the stakes are architectural, not cultural. Firearm proprietors frequently consider SAPA a Second Amendment dispute, but SAPA is additionally a federalism dispute, a separation of powers dispute, and a sovereignty dispute. That's why both factions are invested. Whoever prevails regarding SAPA prevails far beyond weaponry. Essential points. SAPA is a prototype, not an isolated occurrence. Anti-commandeering principle is in play. Outcome influences alternative policy confrontations. Immigration, narcotics, expression, SAPA became significant because it translated theory into enforcement actuality. Part 7. Why jurisdictions are resisting. A quiet transformation unfolds among state administrations. For generations, weapons regulation momentum advanced almost exclusively through Capitol Hill or national agencies. But post-Bruin E, states recognized they can combat national weapons enforcement indirectly through refusing participation rather than directly invalidating statutes. Historically, non-collaboration represents how the national government lost confrontations regarding slavery-era escapee statutes, medicinal cannabis, and immigration detainers. If non-collaboration functions for sanctuary municipalities, states argue it should function for firearms. This approach resonates politically as well. State functionaries can inform constituents they're defending entitlements without awaiting Capitol Hill or the High Court. And unlike litigation exclusively, non-collaboration alters outcomes immediately because enforcement demands personnel. Essential points. States presently combat weapons control through non-collaboration. Sanctuary-style approach possesses historical precedent. Non-collaboration influences enforcement immediately. National authority frequently depends not upon statutes but upon cooperation. Part 8. The High Court's calculation. The present High Court dislikes hurried disputes. Expedited petitions generate chaotic scheduling complications, incomplete factual records, and procedural snares. Bruin required years to mature before the tribunal accepted it. So did Heller. So did Caetano. SAPA follows an identical trajectory. If SAPA returns following final judgment with a clean record, clearer facts, and narrower inquiries, it becomes substantially simpler for the conservative faction to accomplish dual objectives simultaneously: defend anti-commandeering and clarify restrictions upon national weapons enforcement collaboration. Thomas, Alito, and Gorsuch have each indicated interest in those inquiries, even absent action in urgent posture. Barrett has demonstrated caution regarding scheduling. Kavanaugh prefers incremental clarification. The tribunal could simply await the appropriate procedural mechanism. Essential points. The tribunal prefers mature disputes, not expedited petitions. Sapia strengthens once prohibition inquiries are resolved. The conservative faction maintains interest in structural federalism. Occasionally, delay signifies avoidance. Alternative times, it signifies preparation. Part 9. The Justice Department's deadline. With the rejection finalized, the dispute returns to the trial tribunal, where the Justice Department must decide: constrict the prohibition as pledged or defend the prohibition as inherited. That determination isn't purely legal, it's political. The Trump Justice Department doesn't wish to possess a comprehensive prohibition against a firearm-protective state statute entering election season, and they informed the High Court they wouldn't. But constricting a prohibition isn't automatic. It demands submissions, briefs, and justification. The longer the Justice Department delays, the more pressure Missouri applies and the more oxygen SAPA advocates obtain. Delay here becomes headline material for states observing the experiment. Essential points. Dispute presently advances upon the Justice Department's schedule. Constricting the prohibition carries political cost. If delayed, Missouri employs delay as evidence of overreach. Procedural maneuvers matter because scheduling frequently determines outcomes in federal litigation. Part 10. Where this confrontation proceeds. Now, with the High Court officially withdrawing, the confrontation advances into a phase where tactics outweigh headlines. 3 realistic trajectories exist, and each carries distinct impact upon how SAPA statutes evolve nationally. Trajectory 1. Constricted prohibition. The Trump Justice Department could honor what they informed the High Court and petition the trial tribunal to scale back the prohibition. That would permit SAPA provisions to function precisely as Missouri intended, particularly the non-collaboration components connected to anti-commandeering. If that occurs, SAPA becomes not merely theory, but a functional template which alternative states can replicate. And if SAPA operates in real time, it becomes substantially harder for tribunals to eliminate subsequently. Trajectory 2. Complete defense of the prohibition. The Justice Department could alternatively do nothing, delay, or reinforce. That would leave Missouri blocked and compel the confrontation to return to the High Court, with a cleaner record, stronger factual posture, and a sharper inquiry. Can the national government treat non-collaboration collaboration as enforcement. Missouri would then argue not merely charter injury, but political betrayal, that the government violated a pledge it employed to secure the rejection. The optics matter, particularly in federalism confrontations. Trajectory 3. Legislative reverberations in alternative states. Irrespective of Justice Department action, alternative legislatures already observe. If SAPA endures, even partially, state legislators in conservative states will replicate it for firearms, then apply it to alternative policies, immigration detainers, expression enforcement, emergency mandates, information sharing. SAPA was always dual purpose. It functions beyond weaponry. That's why the national government cares. Across all three trajectories, one element remains constant. The SAPA principle endures. The inquiry presently isn't, does SAPA perish, but how extensively does SAPA proliferate, and in what configuration? Missouri doesn't require perfection to prevail. It merely requires feasibility, and feasibility is what it possesses. Essential points. The subsequent maneuver occurs in the inferior tribunal, not the High Court. Justice Department's selection presently shapes federalism more than the emergency rejection did. Missouri's prototype is already being examined by alternative states. Endurance maintains the confrontation alive, and endurance is what SAPA achieved. A portal that remained open. The headline from today shouldn't read rejected. It should read incomplete. The High Court didn't destroy SAPA. It didn't validate SAPA. It preserved SAPA alive and dispatched the confrontation back where it can develop. In federal litigation, endurance constitutes momentum, and SAPA endured again. If you value the Second Amendment, the genuine battle isn't exclusively regarding weaponry. It's regarding who executes statutes, who refuses to execute them, and whether states retain authority to decline. SAPA compels those inquiries into visibility. If you found this analysis valuable, or you believe additional individuals should comprehend what's genuinely occurring in these disputes, make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.